I sausage pizza. That's what our family does every Groundhog Day. He did see a shadow and he went back in. So we have winter for 6 more weeks, but it's supposed to be 58 on Thursday. So on Thursday, you wish you saw there were 17 bills introduced in this committee in one day last week. So no, they do not. I agree. We won't have a hearing on all of them, just so. Okay, we're going to start off with requests for bill introductions from the committee. Do we have any? Okay, I have one. I'm asking for 26 RS 2376, and it provides that tenure at post-secondary educational institutions is not a property right. Are there any questions or objections? Ask a question. Yeah, good. I'm glad you want to ask a question.
Thank you, Madam Chair. Isn't that still an active bill from last year?
Yeah, the bill from last year is very broad and has a lot in it. This is much more simple. This is just a much pared down version.
Thank you, Madam.
Any objections? Seeing none, then we'll request for that bill to be introduced. Any other bill introductions? I didn't see any more from the committee. Any bill introductions from the audience? Requests for bill introductions from the audience? Come on up. If you'll just introduce yourself, that'd be great.
Good afternoon, Madam Chairman. I'm Terry Lois Todd, Register of Deeds, Leavenworth County, Kansas. I request the introduction of 26 RS 2437. It's a new notary public category, is created by this bill for real estate documents.
Okay, and are you asking for that on behalf of someone?
Representative Bohai is working with me on this, and as Register of Deeds, I see a lot of fraud. So.
Okay. Any other question? Any questions? Anybody? Okay. Then any objections? Okay. Without objection, we'll request for that to be introduced.
Thank you.
And I should go back and say that bill that I introduced is just on behalf of myself. Okay. Anyone else? Representative, come on up. Welcome to committee.
Thank you, Madam Chair. Representative Meyer here requesting 2026 RS 3354, the Kansas Corporate Power Reset Act. It provides that domestic and foreign corporations shall not possess power to engage in election or ballot issue activity.
Okay. Committee, do you have any questions? Okay, or objections? Representative Bohai, question?
Sorry, I guess I am wondering why it's coming here, not elections. Thank you.
Understood. It was recommended by the revisers that I bring it here. I'm not entirely sure why, but that is the reviser who is working on this bill told me to do.
Sorry. Thank you. Thank you, Madam Chair.
Yeah, good. That's a good, great answer.
It was a good question.
Any other questions? Any objections? Okay, without objection, we'll request for that to be introduced.
Thank you, Madam Chair. Thank you, committee.
Okay, any other bill introduction, requests for bill introductions? Come on up. Welcome to committee.
Okay, I think we're good now. Yeah. Good afternoon, Chairwoman Humphreys and members of the committee. I'm Brenna Vazowski with Kansas Appleseed, humbly requesting the introduction of 26 RS 3313. This bill would require the implementation of an automatic enrollment or opt-out court date reminder system for the purposes of sending notifications to individuals, reminding them of such court dates utilizing text message, email, phone calls, or mail.
Okay, do we have any questions? Any objections? Okay, without objection, we will request for that bill to be introduced. Thanks for coming to committee. Okay, I hope everyone knows this is the last day to request bill introductions. Everyone good? Okay, no one? I guess I'll ask again at the end of the meeting, but okay, well, we'll pause for now. Committee, we have a committee member that needs to leave early. We're going to go ahead and do work a bill. We're going to work 2243. It was the bill that had to do with our military installations and the sync MOU and that kind of thing. So I will ask Jason to give us a little brief, just a reminder about that bill.
Thank you, Madam Chair. So HB 2243 43 is, as you mentioned, about children in need of care or potentially in need of care. This would require the Secretary of Children and Families, when they're investigating a child who is potentially a child in need of care, and the parent or guardian is a military personnel, that the Secretary is to refer those that family to the appropriate military organization or the Military Family Advocacy Program for services. And further, the Secretary will have to do some memorandum of understanding work with the various military installations in Kansas.
Okay, thank you. If you all remember, there was a little bit of question when we had this bill if it applied to the National Guard. And so I worked with the parties, and I do have an amendment on that to satisfy that. So we'll go ahead and pass out that amendment and let you all take a look at it. It was put together by the different groups to kind of figure out, to answer the questions that we had during the committee. So take a look at it. I think it looks more complicated than it actually is. Jason will explain to us exactly what the amendment is after you've had just a minute to look at it. Okay, Jason, could you explain to us a little bit about the amendment? Thank you.
All right, thanks again, Madam Chair. So the amendment does look complicated, but it's fairly straightforward. You can see kind of from the title, we're making clear that in lines 2 and 3, creating a referral process for cases involving children of military personnel to provide families with services that a military family advocacy program offers. That's still the big picture goal. And to do that, the Secretary for Children and Families to enter into a memorandum of understanding with military organizations rather than installations. So the title kind of tells you exactly what we're doing here. One change in line 10, they requested preliminary be taken out, so it makes an investigation. So that is one change, not related to what I just talked about. And then further down, it's just to make clear that when they find out a person is military personnel or is a military personnel, as my proofreaders told me, the Secretary shall make a referral to the appropriate military organization to provide the family with services that a military advocacy program offers. So the referral or the connection is to the organization that then gets them to the program and not a direct connection to the program. And then in subsection B, it looks like we do the same idea, flipping from the program to the organization. And at the end of that subsection in line 20, near the end, we say specifically which installations or organizations we're talking about. So the MOUs will be with the following military organizations: the United States Army Garrison Fort Riley, McConnell Air Force Base, Fort Leavenworth, and the Kansas National Guard. So they're spelled out specifically. And I think that's it.
Okay, thank you. Committee, what questions do you have of Jason or just in general about the amendment? Representative Carmichael.
Thank you, Madam Chair. I think actually my question is most properly directed toward the maker of the amendment, which would be you. When I've talked to people around the State House here who are in the Guard, they told me that they're not at all sure that the Kansas Guard really has this program set up and operating. Do we know if it is up and operating, and do all families of Guardsmen have access to the program? Because that wasn't what I got for some active duty Guardsmen in the legislature.
I don't have any idea.
Yeah, I don't either. Thank you.
Representative Goddard.
Thank you, Madam Chair. Representative Carmichael, I believe that the Guard does not have a family advocacy program, and that is why there would be needed to be coordination with the National Guard in any matter that came up, and whether or not people could be referred to Fort Riley or McConnell or one of these other areas. The complicating factor is if somebody's on active duty and they happen to live in Idaho and there's a situation that comes up, that would have to be handled, you know, on a one-on-one basis as to how they're going to do it. And I think we should leave that to the National Guard to handle. Thank you, Madam Chair.
Okay, thank you. Any other questions? Okay, with that, I will move that we amend House Bill 2243 with the amendment that is before you. And I'll ask for a second. Representative Goddard seconds. Any more discussion on the amendment? Representative Carmichael.
Thank you, Madam Chair. I think this is all well-intentioned. Don't get me wrong. And I think it could be beneficial for service members and their families. And I want to do the right thing. But I'm just not at all clear if this program exists for guardsmen. And we may have a guardsman in the audience who could answer that question very easily, but that's up to the chair, of course. But I just don't want us to make a mistake here. So I think we need to figure out whether there is a guard program, because I don't want to give guardsmen and their families false hope or false assurance or put people through unnecessary hoops. They've already been through enough.
I am happy to have a guest come up and speak to that. Thank you. If you could introduce yourself, and that would be great. Thank you.
Good afternoon, Madam Chair, members of the committee. Lieutenant Colonel Keith Marshall with the Adjutant General's Department in the Kansas National Guard. The representative is correct that the National Guard does not specifically have a family advocacy program. However, we do refer members who qualify for it to the relevant active duty component. So not all guardsmen qualify for it. It's those that are on orders or those who are full-time National Guardsmen, like myself, who is an active Guard reservist. So my family would qualify for the program, but if something were to happen, then we would refer the case for my family to an active duty unit for it. So the addition of Kansas National Guard in the statute is just clarifying that if a National Guard case arises, the DCF will coordinate with the National Guard, and the National Guard will decide the right course of action for that family.
Okay, thank you. So you don't see any conflicts or anything with?
I'm sure, no. We are very happy with the language
Okay,
here.
great, thank you.
Madam Chair, if I might just
Of course,
address
go
this
ahead.
briefly. Though, but for the classic part-time guardsman, you know, 2 weeks a year and 1 weekend a month or whatever, is there a program for those folks?
Madam Chair, Representative, there is not a program for them unless they are on the appropriate military status, at least through the Department of Defense, Department of War. So this only qualifies to National Guardsmen who are on orders.
Okay, any other questions, committee, or any other discussion about the amendment? Okay, seeing none, I'll close on my amendment and ask that you pass it favorably. All those in favor say aye. Aye. Opposed, no. Okay, the amendment passes, and we'll now, I'll ask, are there any other amendments for House Bill 2243? Okay, seeing none, we'll have discussion on House Bill 2243. Does anyone have any more discussion? Okay, do we have a motion?
Thank you, Madam Chair. I move that we pass House Bill 2243 as amended favorably for passage.
Do we have a second? Second by Representative Goddard. Okay, any more discussion on this House bill? Okay, seeing none, Representative, you may close.
I close and move my motion.
Committee, you've heard the motion to pass House Bill 2243 favorably for passage as amended. All those in favor say aye. Aye. Opposed, no. Okay, then we have passed House Bill 2243 favorably for passage. Thank you. And thank you for your work on that, everyone. Okay, we will now move on to a hearing. We're going to hear House Bill 2519 first because of, I thought she was. Oh, yeah. Okay, sorry. We're going to do House Bill 2519 first because we're waiting on someone to get here for House Bill 2518. So if we could have the reviser give us a brief on House Bill 2519. Thank you, Jason.
All right. Thank you, Madam Chair. We did this last time. I was sitting there and I didn't introduce myself, so I'm out of practice. Jason Thompson, Revisor's Office. House Bill 2519, you have what hopefully, for those of you who have been around, is the customary open records review packet. This is the annual legislative review of exceptions to disclosure of public records under the Kansas Open Records Act. You'll note that this is one of the only bills that is requested by someone on behalf of the office that I work for, and it's required by KSA 45-229, which is one of the statutes in the bill. Essentially, every July 1st, 5 years after the enactment of a new or substantially amended exception, those exceptions expire unless you review and reenact them. So there's a rolling review process, and we're looking back 5 years for things that were substantially amended or newly enacted in 2021. So on the back of, or on the second page of the memo, or the back of my first page, you have the list of 2021 new and substantially amended Kansas Open Records Act provisions. There are 5 listed there, and all 5 of them are in the bill, so I could briefly kind of highlight those for you. The purpose of this review is defined in, or specified in KSA 45-229H. You're directed, the legislature is directed to review these exceptions before expiration and consider a list of factors, including what records are affected by the exception, whom does the exception uniquely affect, what is the identifiable public purpose or goal of the exception, and whether the information contained in the records may be obtained readily by alternative means and how it may be obtained. Because remember, these are exceptions that generally make items not public records or make them confidential, and the interest of the state and the Open Records Act is open records. So that's kind of the whole background of why this bill exists and what your role is in the process. I'll try to briefly highlight the statutes. You have both the statute in the bill that shows you where the amendment would be, right? So striking provisions, and you also have in the bill packet, if you got a nice color copy or you have access to the PDF, we've highlighted the provisions in the statutes. So the first one is about, it's in Chapter 8, it's about driver's licenses, and there are records maintained by the division that are confidential and not subject to Open Records Act, related to, it looks like names, addresses, telephone numbers of driver's license holders. So that one you're being asked to renew. There is one in 22A 243 about the State Child Death Review Board. And there's a provision enacted in 2021 that is set to expire regarding, it actually is the opposite of an exclusion. It's allowing the entity to disclose records that are otherwise confidential on the Child Death Review Board. So I think this was a substantially amended exception that allows disclosure. And oddly enough, you have some opposition testimony to renewing this one. So I would direct you to consult the Child Death Review Board's testimony. They would actually recommend you not renew this disclosure opportunity, which would have the effect of leaving those records confidential or not disclosed as allowed under that subsection. So it gets kind of complicated because of the nature of that exception, but our office presented these to the legislature as things that need to be reviewed, and they are asking you to consider that specific provision and not renew that one. So just wanted to point that out. And then the third one, unfortunately, is in a very long insurance statute, KSA 40-221B, and that's why your bill is so long, and that's why your memo is so long, because that statute seems to go on for pages and pages and pages. But there's one specific provision that enacted a confidentiality provision. If I can find the highlighted copy, I'll point it out to you. It is a subsection capital G under, I can't even figure out the subsection structure of this section because it's so dense. But there is a particular subsection that has a renewal provision, and it's being removed so that it would stay in effect in perpetuity. Let's see if I can find it in the bill. Point it out to you. My apologies. I thought I had this flagged. There it is. It's on the top of page 20. So if you're looking at the bill, it's on the top of page 20. There's an exception about certified reinsurers and certain information. It is set to expire. If you remove the provision, it would stay in effect in perpetuity. Those records would be confidential and not subject to disclosure. Okay. The other ones, real quickly. 41-353 about alcohol fulfillment houses and certain records that they maintain. And 75-782 about elder and dependent adult abuse multidisciplinary teams. So I can also point those out to you if you'd like to look at them in detail. They're a little shorter statutes, a little easier to find near the back of the bill. Pages 46 and 47, those are a little bit more self-contained. So hopefully that gives you an idea of which ones you're looking at. You can do your statutory review that's required, and we can help you with that to the best of our ability. So happy to answer questions.
Okay, thank you. Questions, Representative Vaughn.
Thank you, Madam Chair. Thank you, Jason. If I'm not mistaken, I remember when we passed the law for the Child Death Review Board, CORA exception. So I'm thinking it wasn't that long ago. Could you remind us when that originally went into law?
So, Madam Chair, based on the review that we do and the 5-year look back, it should be 2021. This particular provision should be from 2021.
Okay. Because I was reading the opposition testimony and they're claiming or suggesting that it hasn't been utilized in the last 5 years. That's why the sunset shouldn't be allowed to be eliminated, or I don't know if I said that correctly, but why the sunset should remain essentially. But I'm wondering if perhaps that isn't enough time to allow for the use of that. So anyways, that's helpful context. Thank you.
Any other questions for Jason? Okay, thank you. Okay, committee, this is one of those bills that we have every year that there's actually, we don't really have proponents. But, I mean, it's just something that we have to do every year, and we look at these exceptions. But this time, we do have this opposition. So I just would ask you to look at it. Thank you, Representative Vaughn, for just drawing our attention to it, and Jason also. So look at it and see what you think about it. We'll just figure out what the will of the committee is according to that exception, but it's not really an exception when it expires. And when we work it, we can talk about it. But are there any questions? And the proponent is, or the opponent is written only, so we can't exactly ask questions. I do think they're here. They might be willing to answer a question, or yes or no. Okay. Does anyone have a question for the opponent? Representative Carmichael.
Thank you, Madam Chair. I'd be happy to hear from the opponents because that would make the most sense, or the reviser, but somebody needs to kind of explain to me. I see on page 5 at the top where we are striking the sunset, but I'm not clear on where the language is that is the subject of this concern that the board has. So if maybe that
So
somebody could help me find it.
Okay, or do you feel comfortable answering the question? I mean, I know you wanted to be written only, so it's just totally up to you. But and if you can explain, that would be helpful to the committee. Just go ahead and introduce yourself. Sure. Thank you for coming.
Yes, Madam Chair, members of the committee, Sarah Hortenstein, Executive Director of the State Child Death Review Board. The language is, I believe, on the top of page 4. That's where it starts talking about the confidentiality requirements of the State Child Death Review Board. And on the bottom of page 4, 6A, line 39, the provision that we would like to sunset is allowing the State Child Death Review Board the ability to disclose to local and county entities for the purposes of local child fatality reviews.
Okay, thank you. Does anyone have any questions? Okay, seeing none, thank you. Okay, is there any other discussion on House Bill 2519 by the committee? Okay, do think on this and look at the testimony, and then we'll work it. I'll let you know when, later this week or next week, of course. So, okay, because we have to do it. It's something that the Judiciary Committee gets to do every year. So, okay, with that, I'll close the hearing on House Bill 2519. And we will go ahead and open the hearing on House Bill 2518. And we'll hear from Jason. Thank you.
Thank you again, Madam Chair. Jason Thompson, Revisor's Office, 2518, right? Make sure I grab the right one.
Yes.
A lot of bills going on right now.
Yeah.
All right. House Bill 2518 increases the criminal penalties for certain violations of the crime of breach of privacy. It also modifies the culpable mental state required to commit such crime. I start with section 4 in the bill brief, and I'll do that again here because that's where the crime of breach of privacy is actually amended. Starts on page 5, I believe. No, yes. Starts at the top of page 5, right? So that's the actual crime and the amendments to the crime. The first 3 sections are related amendments that I'll cover after I talk about the crime. The bill changes the culpable mental state in this crime from knowingly and without lawful authority to intentionally and without lawful authority. And if you've been around a little while, you remember me running through my little criminal procedure professor mode where we talk about culpability terms, and right, intentionally is the highest burden of proof, knowingly is right below that, recklessly is the third, right? So intentionally, knowingly, recklessly. Those are the 3 in our criminal code. So this would move from the middle one to the top one. And partially, it's because there is a specific intent requirement already in the law for these particular provisions. So that there are certain ones where you do something knowingly with intent to do something, which makes it a knowing crime with an intent crime. So you have to prove intent. So the prosecutors essentially came and said, let's just make it an intentional crime. It just makes everything clearer. It probably already was as a matter of actual proving this crime, an intent crime, but this makes it clear. Intentionally is the burden or the culpability. The bill also talks about the language in subsection A6, which is one of the key provisions that leads to increased penalties. And you've amended this one in the last few years. This is the one about installing or using devices to record someone in a state of undress or through their undergarments and that sort of thing. That's the breach of privacy that you've done a lot of work in this subsection in the past. The big thing that it does is focus on the terms device or software to record rather than some various other outdated language. And also specifically talks about, the nude body or the undergarments worn by another identifiable person, and it keeps the without the consent or knowledge part that's already in current law. So if you look at that subsection, I think most of that language is cleanup, but it might make it a little bit clearer as well what the violations are. And then subsection A7, which is the other key one that has increased penalties, is unchanged. And that is when you disseminate or permit the dissemination of anything obtained in violation of A6, right? So those are really the 2 things we're going to be talking about. A6, these recordings, and A7, dissemination of those recordings. So then, shifting to the main focus of the bill, finally, I think. Sorry for that lengthy exposition. The bill increases the penalties for A6, which again is the recording. It's currently a severity level 8 person felony or a 5-person felony on a second or subsequent conviction within the previous 5 years. What's added is that it is a severity level 5-person felony even on a first conviction if the victim is 14 years of age or older, but less than 18 years of age. So if the victim's between 14 and 18, it's a 5 first time. Current law, and then A7, which again is disseminating or permitting dissemination of the things obtained in violation of A6, is a severity level 5-person felony. And the bill adds for both of those crimes, A6 or A7, or an attempt, conspiracy, or criminal solicitation to commit either of those, they will be off-grid person felonies if the offender is 18 years of age or older and the victim is less than 14 years of age. This is what most of you would remember as a Jessica's Law provision. This is the language we use to make crimes involving victims under 14 off-grid felonies. And so we've used this language that's used in other places. For these two particular violations, A6 and A7, if the victim is less than 14 and the offender is over 18, this is off grid, not on the sentencing grid, and subject to a much longer sentence. Because of that, we also have rules that say the provisions of attempt, conspiracy, and criminal solicitation that normally reduce penalties do not apply. And that's the second half of the bill brief. So sections 1, 2, and 3 are the attempt, conspiracy, and criminal solicitation statutes in our criminal code. For attempt, the general rule is an attempt to commit an off-grid felony is a non-drug severity level 1 felony. But that rule doesn't apply to Jessica's Law offenses, and this provision is added to that list. So you would not get a reduction to a level 1. It would remain off-grid, even if it's an attempt to commit this crime. Similarly, for conspiracy, it reduces it 2 levels. That rule doesn't apply to these offenses. And for solicitation, it normally reduces it 3 levels from an off-grid to a level 3, but that rule doesn't apply to Jessica's Law offenses, and this would be included in that list. So, big picture, just kind of zooming back out, culpability change from knowing to intentional, which may be slightly semantic, but obviously important. Changes in some terminology in A6, which is one of the key provisions that gets you increased penalties. No changes to A7, which gets you even greater penalties in some cases. And then basically increasing the penalty pretty substantially if the victim is between 14 and 18, and making the violation off-grid when the victim is under 14 and the offender is over 18. That's kind of the big picture of everything that I just talked about. All right, see if I can answer questions or if I confused you.
Well, we have to think very hard in this committee. Does anyone have any questions for Jason? I do just have one question. The section 4 where they're changing the culpable mental state. So it's harder to prove intentionally than knowingly. And so what was kind of the, seems like that goes a little different than sections 1, 2, and 3. So do you have a thought about that?
Sure, Madam Chair. So just a quick reminder that the first 3 sections are just kind of related amendments to section 4. So you can really kind of just ignore them other than for the penalty provision.
Okay.
For whatever reason, that's how long story short, there was a Supreme Court case that said attempt, conspiracy, solicitation reduces the levels. You didn't carve out an exception, so it applies to Jessica's Law cases, even though you said it didn't. So the legislature decided to put a provision in each of the Jessica's Law statutes and in each of those 3 statutes to make it double clear that those rules don't apply to Jessica's Law cases. So now if we add a Jessica's Law offense, we have to amend those 3 statutes and the one we're in. So that's kind of a long backstory there, but you can kind of ignore those 3. They're just related to the off-grid penalty. And if you took out the off-grid penalty, I would take out those 3 sections. So you can kind of dissociate them in that way. But to your point about section 4, the real meat of the bill, the breach of privacy crime, if you look at some of the violations under subsection A, it currently says breach of privacy is knowingly and without lawful authority doing any of these more than 8 things. I just see 8 right here. But you'll notice that number 3, entering with intent to listen, right? There's an intent. So you have to prove at least that element with intent, even though the culpability is knowingly up above. Number 6 that you're amending in this is it has an intent element. That's further down, with the intent to invade the privacy in line 33 and 34, right? So again, you've got an element that requires intentional culpability. And so I think the goal of the folks who asked for this bill is to just make it cleaner by saying it's an intent crime.
Okay.
And
That's
rather
helpful.
than having it be a slightly confusing where some elements are knowing and some aren't. But it is a change.
Thank
It is a
you.
change.
Thanks for that explanation. That was helpful. Any other questions for Jason? Okay, thank you so much. Okay, committee, we will now hear from our proponents, Joshua Stewart, the Chief DA, on behalf of Mark Bennett. Welcome to Topeka. glad you decided to make the trip from Wichita. We appreciate that.
There we go. I'm loud anyways, so never notice. Thank you, Madam Chairwoman, members of the committee. My name is Joshua Stewart. I'm with the Sedgwick County District Attorney's Office. Here speaking on behalf of Mark Bennett, our district attorney, as well as Kansas Counties and District Attorneys Association in support of House Bill 2518 to amend the breach of privacy statute. I had a case last year that really gave me the impetus to make these changes or propose these changes to the committee. I've been a prosecutor going into my 17th year now, specializing in domestic violence, sex crimes, crimes against children for probably 11, 12 years of that. And this is the first time I've had a chance to try a breach of privacy case in Kansas. And when I sat down to do the jury instructions, which I don't know if you've all had the privilege of serving on a jury before, but the jury instructions are where the jury's actually told, here's what the law is, because we don't expect jurors to know all of that. And I was candidly shocked at how complicated the jury instructions were for a breach of privacy. First-degree murder is 2 elements. Breach of privacy was something like 8 or 9 elements. I can't recall exactly off the top of my head. And that's okay. That's kind of how these things go sometimes. But it became very clear how confusing this was for a jury. I believe the one question that we had earlier for the revisor was about changing that knowingly to intentionally. And that was my proposal. Intentionally is the highest standard unless you start talking premeditation, which only applies to first-degree murder. And the state is fine, excuse me, that my office would be fine with an intentional standard, because that's ultimately, I think, as the revisor said, what we're doing anyways. And it clarifies things, so we're not instructing the jury on multiple mens reas or mental states that the defendant has to have. Just make it intentional, make it the highest one, that's fine. It also gets rid of, in the statute, it talks about for the purpose of, which I think we all know what that means, but it seems to insert yet another mental state that isn't defined in the law, which most of us would just call intent. So let's just get rid of it, call it intent. The statute then also, or excuse me, this proposal would also bring breach of privacy in conformity with several other criminal statutes in Kansas. If you look at the proposal to change the punishment for a victim who is under the age of 18 but 14 or over to be a level 5 severity personal felony, that would be in conformity with things like sexual exploitation of a child, or most of us know that as child porn, or indecent liberties with a child. So this just really brings consistency to the law, and then adding the provision for children under the age of 14 who are victims becoming a Jessica's Law offense is, again, just in conformity with the rest of the law. In reality, this is going to be a needed change because, as I stated in my written testimony, the technology behind this is more accessible than ever. It's smaller, it's better, it's cheaper, it's easier to install and to access. Used to be, when the statute was first written, somebody would have to actually hide a cassette recorder somewhere, a bulky cassette recorder. That is not the case anymore. We're going to see more and more of these cases, and we're going to see more and more children caught up in this sort of thing without their knowledge, and they're forever going to wonder if their images are out there on the internet. And as we know, once something's out there, it's basically impossible to get rid of. So increasing the penalties is appropriate. I would ask that you pass this bill. I understand that there was another proposed amendment to replace the word videotape with video. That makes perfect sense to me. I would support that. I know that there's another amendment by Mrs. Garnier to remove the lawful authority section. I understand that. I certainly appreciate the spirit of that, and I can understand that there may be some concerns there regarding parental rights and that sort of thing. So I leave that up to the good wisdom of the committee, how they want to approach that. But I certainly am appreciative of the spirit of that. But I stand open for any questions. Thank you.
Okay, committee, I think we'll go ahead and take questions. Does anyone have any questions for Mr. Stewart? Yep, Representative Carmichael. Oh.
Thank you, Madam Chair. The first might be directed to the revisor or perhaps our conferee has it handy. But could we get a copy of the pattern instructions for Kansas criminal instruction? He was referring to the existing one and saying it's complex. It would be helpful if we can get it from the reviser. I'm no longer an active Kansas lawyer, so I can't get to it online anymore. I don't know, I have
Jason,
to
is
have it
that
right
something you'd like
now,
to
but.
do? I mean, you could do, or, okay.
And it's fine if after the hearing or at some point, so we know what he was talking about.
Yep.
And I think it will confirm what he said, but I'd just like to be able to see it.
Okay. great.
My substantive question for our conferee, you mentioned that there's what you described as a lawful authority provision in this bill that you understand that some people may have some objection to. Since we have no opponents, it's going to be hard for me to find out what that objection is, at least without at least asking you if you can kind of explain the legal principle that underlies the concern. And maybe if you've got a good idea about how we can remedy that concern, I'd certainly be interested in hearing it.
Absolutely. Thank you for the question, Representative. I'll be honest, I forget the name of the case off the top of my head, but there is a case related to breach of privacy that talks about parental rights to, install a camera, essentially like you install a security camera on the outside of your house to do the same on the inside. Now, the case doesn't go into great detail about, sensitive areas, or certainly doesn't allow for, a parent to install it for prurient purposes. But, and that's where this language clarifies that. Now, in terms of objections to the proposed amendment to just say there is no lawful authority to do this sort of thing by a parent in the first place, I guess I could see that being questioned by the courts of appeal here, because there probably is some sort of, or there possibly is some sort of existing parental right, again, to ensure the safety of a child if, the certain circumstances are met. So I didn't try to actually define what that right is in the statute, instead just to negatively define what it certainly isn't, which is there is no parental right to do this sort of thing for prurient purposes. So long as the state can show that that was the intent, there is no parental right. It was kind of an issue in my case where the jury was able kind of later on to hear in a subsequent instruction, yeah, there is this right, and they were told that, the prurient purposes may not be part of it, but through the way it kind of came out, it became difficult for the jury, I think, to understand. This would add clarification, would add a basis for an instruction to them to understand exactly why what a parent in this situation might do would still be illegal.
And so maybe my second and a half question, Madam Chair, is, so have we protected parental rights in this? Because I don't want to interfere with parents who, for a legitimate purpose, videotape their kids in the backyard, for example. It might have been a good idea. I'd have gotten a lot less trouble when I was a kid if mom had a camera in the backyard. And I don't want to stop that. I also don't want to obviously facilitate parents or anyone else taking inappropriate photographs of children. Are you satisfied that we've protected parental rights for legitimate purposes in this bill, or do we need to make sure we have no conflict in the law? Because I sometimes despair of the judgment of the Court of Appeals, despite what many of you have heard me say.
Representative, again, thank you. I think that, again, the reason I didn't try to define what a parental right is, I think that gets really tricky. And I think to include is to exclude. I know there's a fancy Latin phrase for that. I can't remember what it is off the top of my head. But that's why I decided to define it negatively, and that just simply, I think we can all agree that whatever the parental right is, it isn't this. It isn't to record your children in the nude. It isn't to, again, for prurient purposes. Absolutely, absolutely. And I'm confident the statute does not do that. Thank you.
Do we have any other questions from the committee? Okay, seeing none. Oh, I'm so sorry. Representative Barrett.
Thank you, Madam Chair. And so kind of to piggyback off of that question, so let's say you have a parent that is recording their child, and the investigators know it's for sexual gratification, but they just can't prove it. They can't get an admission because you just included this as a negative. even if they can't improve the intent because it's not required for the statute, you could still charge that person under breach of privacy, even if you couldn't prove that it was for sexual gratification, correct?
That's an interesting question. I think ultimately, as a prosecutor, I have an ethical duty never to charge or prosecute a case that I don't have confidence that I could actually secure a guilty verdict on. So if I have no evidence beyond just, and honestly, this happens a lot. We all know what's happening, right? But can I prove it? If I have no evidence to prove it, then it probably would be a hurdle to charging and certainly getting a conviction. That's why, in theory, I don't oppose just saying that there just is no right to do this thing, period. I think it's opening up a whole different issue than, again, which is why I tried to go at it with a scalpel instead of a sledgehammer. If that makes sense.
Okay, committee, any other questions? Okay, thank you so much for being with us. I'll now call up Ed Klump to be our second proponent. Welcome to our committee.
Thank you, Madam Chair, committee members. I am Ed Klump here on behalf of the Association of Chiefs of Police, the Sheriff's Association, and the Peace Officers Association. We're in support of this bill, and we would have provided testimony in support even had we not spotted something we think needs to be amended. I'm just going to cut right to the chase. If you go down to the paragraph of my testimony that's got the bold print in it, we spotted the word videotape, and that's kind of an antiquated term now. And with some of the rulings we've been getting from our appellate courts, we kind of wondered if they would say, well, it didn't go on a tape, then it's not covered in the statute. So we thought it was just a good time to modernize the language in there and strike videotape in those three places I cite and put video in instead. And I will just stand for questions.
Okay, committee, what questions do you have for Mr. Klump?
Good.
Okay, I think you got off easy.
Easy.
Okay, thank you
Thank
for
you.
being a proponent. We appreciate it. Okay, now we have Kimberly Garnier, private citizen. Welcome to our committee. You would just introduce yourself when you, is the microphone on? Yep.
Thank you. Good afternoon, Chairwoman Humphreys and honorable members of the committee. Thank you for allowing me this opportunity to speak. I've expanded my testimony, and Lene was nice enough to offer to provide you with copies of the updated version. I'd also like to thank Mr. Stewart. He was the prosecutor in my daughter's case, and he worked so hard, and I'm so grateful for him. My name is Kim Garnier, and I'm the mother of a 17-year-old victim who was secretly video recorded with a hidden camera in the privacy of her bedroom in various states of undress by her stepfather. The offender in my daughter's case was not held accountable at trial due to the leniency of the current standards of breach of privacy. The man who did this to my daughter was a Marine Corps officer who served as a medevac helicopter pilot in the Middle East and received his doctorate from the University of Southern California. He is a smart man who presents well, which allowed him to spin a tale that made him out to be the victim during the trial. The jurors told the prosecutor after the trial that under this statute, it doesn't matter why a stepfather secretly records his teenage stepdaughter without her knowledge or consent and without my knowledge or consent. A 17-year-old is a young woman who should have the same right to privacy in her bedroom and bathroom than an adult woman deserves. We wouldn't allow a parent to watch a young woman undress in her bedroom as she showers or uses the restroom. So why would we allow the same parent to repeatedly watch with the hidden camera? Whether it's for sexual gratification or not, we would not allow a parent to do this. Privacy violations like this one cause immediate and long-term harm. In my daughter's case, the crime and the lack of accountability has had a devastating effect on her. She was violated in the most intimate way by someone she trusted. She now showers and changes her clothes in the dark. She avoids public areas with prominent cameras and will often have a severe panic attack if she sees one. Because cameras are almost everywhere these days, she isolates in the safety of her bedroom. My daughter essentially is on house arrest while the man who did this to her roams free. Nobody's daughter should have to experience what my daughter has been through. I appreciate the efforts to strengthen the law, but I think there is a loophole. The amendment seems focused on sexual exploitation without also focusing on the equally serious and harmful problem of privacy breaches. We don't simply want to prevent sexual exploitation. We want to protect people during their most vulnerable moments, even when sexual gratification is not the most obvious motive for the violation. If my daughter went to school and told a teacher that her stepfather watched her get undressed or watched her in the shower, that teacher would report it to the police, and rightly so. Why can people get away with secretly what they wouldn't get away with openly? A 17-year-old woman should have the same right to privacy in her bedroom and bathroom than an adult woman has. We wouldn't allow a father to repeatedly watch in person his daughter disrobing in her bedroom, taking a shower, or using the toilet. So why would we allow the same parent to secretly watch by using a hidden camera? Whether it's for sexual gratification or not, we wouldn't allow a parent to do this. Whether in person or by hidden camera, being watched without permission poses a significant breach of privacy, a violation of the most personal sort at a moment of utmost vulnerability. I therefore urge you to add another provision that protects young women from privacy violations, even when sexual gratification is not the motive, thereby making their bedrooms and their bathrooms safe places for them once again. If you think there should be an exception, please add an exception, but we shouldn't let clever people get away with invading a young woman's privacy unless they can prove they had a good reason, and at a minimum, both parents should consent in advance. My brave and beautiful daughter's name is Talia. If you make the amendments to close the loophole, she and I would like you to consider naming this law after her. Thank you.
Thank you for sharing your story with us. We appreciate that. Committee, what questions do you have? Okay, any first, does anyone else have a question before Representative gets back to his seat? Okay, I think you're up. Representative Carmichael.
I appreciate why you're here. And what happened to your daughter is obviously terrible. Okay? I do have some concern, though, about if you change this law so that it no longer has to do with sexual gratification, so it's just a general privacy law. What about the parents who do want to, for very legitimate reasons, video their kids in the backyard, for example, when they're playing with the kid next door? I mean, I can remember a whole lot of trouble that we got into, and some of it was experimentation by young people who were just developing sexuality too.
Yes.
But I can think of a lot of reasons that parents would want to perhaps even surreptitiously record their kids to keep them out of trouble. How do we meet the privacy expectation of the child while at the same time giving the parent the right to use these new electronic tools to supervise their kids so maybe they won't get into the same kind of trouble I got into? And it was not sex related, I assure you. Thank you.
Representative Carmichael, thank you for that question. It sounds like you had a fun childhood. I think that there is a distinct difference between a bedroom and bathroom than there is a backyard, a hallway, a kitchen. And I'm sure we got in plenty of trouble in all of those locations, but we are not at our most vulnerable in the backyard, in the kitchen, in the hallway. And the expectation of privacy is different in those areas where children, young adults are undressing. I think most children know not to take their clothes off in the backyard or the kitchen. They're more likely to be uncovered or discovered, than when they're bathing. And again, if a parent were to view their child in one of these other spaces, It's a different scenario than, again, if a father or stepfather or another parent is watching them bathe. I don't know anyone who could say that they have good intentions if they're watching their 17-year-old stepdaughter take a shower. So I appreciate that there will be circumstances where, you know, children are in a vulnerable state outside of those areas, but I think we have to focus on what does the most damage to our children, and that's when they're vulnerable and exposed, and they believe that they had a right to their own bodies in those areas.
Appreciate your answer. I'm not sure how to solve what I perceive to be a problem. Thank you, Madam Chair.
You're welcome. Okay, anyone else have any questions? Representative Barrett.
Thank you, Madam Chair. Not really a question, just thank you for coming today. Obviously, your email is the reason we're having this hearing. So thank you for that.
Thank you. Appreciate that.
Okay, with that committee, thank you for being here. We also have, I guess we don't have any written proponent testimony. We don't have any neutral testimony. We don't have any opposition testimony. So with that, I'll close the hearing on House Bill 2518. And thank you all for coming about that bill. We do appreciate it. Okay, and I will go ahead and open the hearing on House Bill 2535. And we'll get Jason to give us a bill brief.
All right, thank you again, Madam Chair. Jason Thompson, Revisor's Office. House Bill 2535 stays in the criminal code. A little different topic here. Provides that certain portions of the crime of cruelty to animals do not apply to any person who catches a feral cat to provide vaccination, spaying, or neutering, and returns such cat back to the location where the cat was caught. The bill is amending KSA 21-6412, that is the crime of cruelty to animals. Under current law, subsection A2 prohibits knowingly abandoning any animal in any place without making provisions for its proper care. And subsection A3 prohibits having physical custody of any animal and knowingly failing to provide food, potable water, protection from the elements, etc., for such animal. These crimes are defined as a Class A non-person misdemeanor for a first conviction and a non-person felony for a second or subsequent conviction. What the bill is doing is adding a new subsection D, which you can find added on page 3 in lines 6 through 9, that provides that those provisions I just talked about in subsections A2 and A3 will not apply to any person who catches a feral cat to provide vaccination, spaying, or neutering, and returns the cat back to the location where the cat was caught after providing the services, the vaccination, the spaying, or neutering. As used in the section, feral cat has a specific meaning. It has no apparent owner or identification, appears to be unsocialized to humans, etc. So we're talking about cats that are picked up, services are performed on them, and they're returned. And in theory, you could be committing a crime under subsection A2 or A3 by returning an animal and not providing for its care. So this would make clear that those crimes do not apply. I specify those two subsections because the other subsections would still be a crime. So you can still not knowingly and maliciously kill a feral cat. You can still not, intentionally use some devices for sport or entertainment on a feral cat, right? So there are still crimes related to these animals, just not subsection A2 or subsection A3. Be happy to answer questions.
Okay, thank you. What questions do you have for the revisor? Okay, seeing none, thank you. We'll go ahead and call to the podium our first proponent, Jasmine Kyle from the Southeast Kansas Humane Society. Welcome to our committee. Hi.
I'm a little short, so I gotta put this down. Thank you, Madam Chairman and members of the committee. Thank you so much for this opportunity to testify today as proponent of House Bill 2535. Again, my name is Jasmine Kyle, and I am the director of the Southeast Kansas Humane Society in Pittsburgh, Kansas. We're a licensed nonprofit animal shelter serving Crawford County and its surrounding areas. I'm supporting this bill today because Kansas's animal cruelty statute was never meant to criminalize humane trap, neuter, vaccinate, return programs, also known as TNVR. But under our current law, unfortunately, due to broad language around abandonment, this can be misinterpreted to place responsible caregivers, shelters, and veterinarians at legal risk for simply returning a sterilized cat to its outdoor home after medical care. That legal uncertainty will only discourage people from helping. When volunteers and veterinarians are afraid to participate, fewer cats get fixed, populations grow, and shelters like mine become more overcrowded, with many of us already being way over max capacity, unfortunately. Now, nationally, the American Bar Association has recognized this evidence-based problem and has urged states to remove legal barriers that unintentionally criminalize humane feline population control. This bill follows that guidance. TNVR improves vaccination coverage of outdoor cat colonies, thus increasing the public's health, decreasing kitten births, and it helps neighborhoods stabilize from those feral cat colonies. No TNVR organization should face potential animal cruelty charges simply for responsibly addressing the growing unmanaged feline population through our humane evidence-based practices. So again, I thank you so much for your time today, and I please ask that you support House Bill 2535 and the work that TNVR Services gives to its Kansas communities. If you got any questions, I'd be more than happy to answer.
Okay, thank you. I think we'll go ahead and do questions now. We just have 3 proponents, so that seems appropriate. So what questions does anyone have for Ms. Kyle? Anybody? Representative Curtis. Sorry.
Thank you, Madam Chair. So how big of a issue is the overpopulation of pets in your area?
In our area, it's quite high. So we're from Crawford County. It is a rural area in the state of Kansas. We get calls, probably, I'm not joking, every single day about cat colonies. So by this amendment with House Bill 2535, it will allow those TNVR programs to continue operating so we can make those drastic, efforts to help our neighborhoods. These programs are needed, especially when you have a female cat giving birth to multiple kittens. One, you want to prevent that for the rest of the colony so it can stop growing, but then you have to spay and alter every single cat, part of that colony, including the kittens too.
Okay, any other questions? Representative Goddard and then Vaughn.
Thank you, Madam Chair. Thank you for your testimony. I live in an adjoining county to Crawford County, and we have a terrible problem with feral cats. In fact, if you want to see how bad it is, just go out and count the number of cats versus the number of squirrels that are killed on your city streets. And there are a lot of them. Thank you for your testimony.
Thank you.
Representative Vaughn.
Thank you, Madam Chair. Thank you for this bill and for your testimony. I just was curious. I was looking at the definition of feral cat, and it says no apparent owner identification. For these types of vaccinate, neuter, spay, release programs, do they typically check for microchips or other forms of identification when they find them?
So the program, at the SEK Humane Society, we do not operate that program, sadly, due to lack of funding, but we've worked with many programs in our area that do have that. And from our work with them, yes. So we also have a microchip reader. They had a microchip reader. That was one of our key things, that whether they came in a trap or that we could safely handle them, that yes, we did, of course, microchip check those felines.
Yeah, just curious. Want to make sure if they do have an owner that they find their way home, but I understand the need for this. Thank you.
Okay, any other questions, committee? Okay, thank you. Oh, I'm so sorry. Yeah, you're so far back there. Representative Carmichael.
I'm just shy and retiring, Madam
Right.
Chair. Like Representative Goddard, this is a big problem, and I'm from the largest urban city in the state, and it's a problem there as well. And in fact, I'd be derelict, Madam Chair, if I didn't mention that one of my constituents about 4 or 5 doors down has done TNR for years, but now with increasing scrutiny and concern about whether someone might get prosecuted for someday, the cats are proliferating again. But this matter that Representative Vaughn brought up about making sure that owned cats get back home, for those who have a chip, it takes a reader, I think.
Yes, it does. So for a microchip, it's literally the size of a grain of rice, but within that microchip, it has the owner's information, can have their name, their address, phone number, the whole 9 yards. And for licensed KDA shelters like mine, we actually keep all of that within our log records. So if for some reason the owner has lost that information, we'll always have it on file for them. So if we were to receive a cat, either as a stray intake or such, that's one of the first things we look for is a microchip to make sure. And then, of course, with the TNVR programs that we have worked with, if cats come in with a, let's say that we believe that they're from another owner, you know, heck, they got trapped with a collar on, but there's no microchip and such, right? We can always take photos. We can always put them on a high intake list of our shelter as well to get them intaken with our facility. So that way we can help find the owner. And then in our area, we actually offer and operate a free social media lost and found page. So we will take photos and we will help share that in our community, being like, hey, there's this really cute cat. There's a collar going through the TNR program. Is there, you know, does anybody have any idea? So yeah.
Well, Madam Chair, I know at least in my community, the people who've been doing TNR without legal authorization, perhaps, they have the little scanners. And so they scan them, and if it comes up, then they take the appropriate steps. And also, they're the people around the neighborhood who we know have scanners. So when we find a cat, we don't have to find a vet who's open. We can take it over to Mary's house and she'll scan it. And if it comes up, then we can get it back home. Thank you.
Nice neighborhood. Representative Bohai.
Thank you, Madam Chair. Quick question. So if an intact feline, which is chipped, comes in and it has an owner, I'm assuming, but that's why I'm asking the question. Do you contact the owner before you do any operation?
So that's through TNVR. So again, we don't personally house that program. So I can't unfortunately answer on behalf of a TNVR program. But for example, at the SEK Humane Study, if we were to intake a stray feline that came in with a microchip during that 3-day business stray hold, we do not alter that cat until, you know, we get confirmation from the owner, you know, like, hey, you know, yeah, I dumped my cat. I don't want it, you know, that type of jazz. Or wait until that legal 3-day threshold is stretched and passed where the cat becomes our property. And then, of course, we do humanely sterilize all of our dogs and cats so they don't have unwanted litters in the state of Kansas.
Thank you, Madam Chair.
You're welcome. Okay, any other questions? Okay, thank you so much for being with us.
Thank you.
I'll now call Terry Humphrey up with the Kansas Pet Advocates, the Executive Director. Welcome to our committee. Is your microphone on?
Testing.
Okay, there it is.
Yay. I'll start over. Thank you, Chairwoman Humphreys and members of the committee. I am Terry Humphrey, Executive Director of the Kansas Pet Advocates Organization, and we, of course, support House Bill 2535. We believe that this is good policy, and we are hopeful that after you hear all of the testimony, you will agree as well. So as you've heard from Jasmine, and I can't do any better than she's done. She's told you all the reasons why trap, neuter, vaccinate, and return is a good policy and how it helps to manage populations of feral cats. And these colonies are a concern in many communities, as we've heard here today. So we know that this is something that communities want to deal with. I've given you my written testimony. I want to go off script just a little bit because of some of the questions that have been asked. And of course, we all agree that humane, trap, neuter, vaccinate, return has community benefits and helping our neighborhoods. And one of the things that I would like to share with you is that Kansas State University has a shelter medicine program. And earlier today, actually because Representative Osborne and I had a conversation. I contacted Kansas State University Shelter Medicine and talked to them about how their work, the work they do on behalf of local communities in trap, neuter, vaccinate, and return. And they do help local communities with these programs. And so how he explained it to me is like here in Topeka, the Community Cat Fix organization that they work with, what these organizations really focus on is two things: communicating with the neighborhoods and the communities in the city, and then educating on what, if there is a problem with feral cats, what to do. And before these organizations get involved in trapping feral cats, what they do is they canvass neighborhoods. When they get a call and they say, we have a problem, and they go and they canvass neighborhoods, talk to people in the neighborhood, knock on doors actually, put door hangers out, and try to determine indeed if there is a feral cat problem. And usually people in the neighborhood know about it and they know where feral cats are. And so then they evaluate the situation. They look for volunteers, and if indeed they're going to go and do the trapping process, they also contact the neighbors and they say, okay, we're going to be trapping on this date, and so please keep your cats in the house on this date. And then they go out and they humanely trap these animals, take them in for medical care. And part of that medical care also is to provide vaccinations like rabies shots. And that's really important for the health of a community. So I want you to know that that's how these programs operate, so that they don't hopefully mistakenly get someone's, Tinkerbell and, bring that into the program. So they really work extra hard to do that, in addition to having and looking for chips and those kinds of things. So I wanted you to be aware of that and to know that our really high quality shelter medicine program at Kansas State University is also helping communities deal with these problems as well. As you were told, the American Bar Association nationwide did a study on trap, neuter, vaccinate, release. They did identify that this is a problem, not just in Kansas, that these words like abandonment are very broad and not necessarily meant for a trap, neuter, vaccinate and return policy, but they noted this is a problem nationwide, and they did encourage states, after they published this report, I think a year ago, to go ahead and look at their statutes and make any alterations to their statutes. And I do want you to know that Texas, Utah, Nevada, South Dakota are among a few of the states close to us that have already altered their statutes to address this concern. And then one other thing I want to say is this legislation is very narrow. It only essentially decriminalizes trap, neuter, vaccinate, and return. It does not say that a community has to have a program. Local ordinances and local units of government are going to decide, and local community organizations are going to work inside their community and decide if these programs are going to exist, and they identify what their own local circumstances are. So it's just decriminalizing. It's not pushing these programs onto anybody who is not interested in having them. I hope this helps. Again, Jasmine did such a good job. She covered my testimony, and I wanted to give you a little more info.
Okay, thank you. Yeah, Representative Curtis has a question.
Thank you, Madam Chair. So I'm glad you mentioned the shelter medicine program, because I went to their 10-year celebration earlier this year, and it's actually a model that other states are starting to adopt. So thank you for that. Do you think by decriminalizing that we will actually see more trap, neuter, vaccinate and release programs. Do you think that that will help? And then if you could just, I think we have read recently that Kansas is actually at a crisis point in overpopulation of pets. And so anything that we can do for spay and neuter, I would think would be directly addressing the problem at a point where we could maybe help get ahead of it and help solve the issue. But so my question really is, do you think that this bill will help encourage more of that type of effort?
I definitely think it will help encourage communities to take this head on and to have more of these programs. And of course, the key is education, right? Just as you said, to, we believe in spay and neutering very strongly and also vaccinating animals. And especially we believe in managing feral cat populations. This is a humane way, and this is very well supported by the public. So it's a really good way to reduce those populations. We think it will help, and we are thrilled to have one of the finest veterinary programs in the country that is also helping guide and educate local communities. So thank you, we do.
Representative Osman.
Thank you, Madam Chair. Thank you for your testimony. Seems like a good program and a good bill. Are there any corresponding programs for canines?
Oh, for spay neuter and or strays?
Yes.
Jasmine, can you help me? These boots on the ground.
As for TNVR for canines, so I've been with the Humane Society for 8 years, and in my 8 years, I have not personally seen one where you are TNVRing a stray dog per se, just because, and this was my own interpretation off of it, is with cats, right, they can really fend for themselves for the most part, as long as they're within those feral colonies. Compared to a feral dog, you're in a whole other bracket, especially within a community, and cross-contamination, because dogs will go further and wider to get to a resource. Now, as for TNVR for canines, I haven't seen it. As for reduced low-cost programs for spaying and neutering dogs, absolutely there is, where there are clinic pop-ups and programs being like, hey, if you're a dog owner and you're not able to pay that $300 alteration fee, then we've got a grantee, we've got a business sponsor, that came through, and we're able to reduce it by 75, 50%. And that's when those programs come in to do that. You're welcome.
Representative Carmichael.
Thank you, Madam Chair. Ms. Humphreys, I don't know if you're familiar with this, but you've been working in this area for a long, long time. In my community, there was at least a time where the TNRs were being discouraged for some of the reasons that this bill focuses on. And the reports that I received back, at least by way of the media, was that when we started, in essence, eradicating cats from the Old Town neighborhood of Wichita, which is a warehouse district that's now been turned into nightclubs and the like, that the rat population flourished. And that when we went back to the old TNR and took them back where they came from in Old Town, that at least anecdotally, not as many rats anymore. Do you have any comment on that? Is that what happens? Is that something we need to keep in mind rather than trap and euthanize type programs, for example, for feral cats?
Well, I will just speak personally, having a farm and a barn and other things like that. We like cats. They're very helpful, and I think you're right that they, there's an order in nature, and they can be very helpful in keeping things in balance. And so it doesn't surprise me that if you don't have cats, that you could have some other animals that are, maybe causing some trouble. I don't know, but.
Thank you. And Madam Chair, I don't mean to shortchange people who have rats. I have a good friend who has rats as pets. So, you can't please all the people all the time.
True. That is true. We know that. Okay, any other questions? Okay, thank you so much. We have one other proponent testimony, Nika Orbaugh from, I think from Wichita, but on WebEx. Mhm.
Yeah, I'm from Wichita. Madam Chair, my name is Nika Orbaugh.
Welcome.
I am the supervisor for Sedgwick County Animal Control, but I do not speak on behalf of Sedgwick County. I come to you as a private citizen. I have over 20 years of experience in the animal welfare world, and I was hired on as a brand new baby ACO back in the times that Representative Carmichael spoke of, where the standard practice for feral cat population control was to trap and euthanize feral cats. It was considered that there was no good place for them, that we would just get rid of them. They were no different than a nuisance wild animal. I am very happy to say that over the last 20 plus years, we have learned and we know better now. They do keep away rats. I can tell you from personal experience, in the Sedgwick County Fleet Yards, they keep away raccoons and possums and other things you don't want crawling up in vehicles and having babies. TNVR is an extremely humane way to control feral cat colonies and help pare down oversized colonies through attrition. Jasmine and Terry both covered the high points very well. I won't rehash their testimony. I wanted to add, though, that the vaccinate part of this is extremely important to me, being in animal control. We, above all else, seek to protect the public from zoonotic diseases and communicable diseases, and rabies is number one on our list. We have had cats test positive for rabies in Sedgwick County, and every single one of them has been part of a feral cat colony where someone did not know or was not aware of TNVR resources. Under the government guidance, we are not allowed to promote TNVR through our department, just because it does violate the current cruelty statute as written due to the broad language. However, we do have a group of wonderful and highly dedicated volunteers in Wichita, Kansas, and the Sedgwick County area, through Friends of Feline, that run an amazing TNVR program that spays and neuters thousands of cats a year. 2,000 to 3,000, somewhere in the upper 2,000s was what they hit in 2025. We are very encouraged by their activity, and it is my personal opinion and my personal hope that by decriminalizing TNVR, I can get to a place where I can petition my bosses to be able to publicly support and help advertise programs like these. Because like I said, over 20 years, we know better now and we know what works. And this is by far the most humane and advantageous and safe way for us to protect our public, not only for communicable diseases, but to show a humane outcome for these feral animals. Thank you.
Okay, thank you so much. We'll see if the committee has any questions for you. Anyone? Okay, thank you. We appreciate you being with us. And nice to hear from someone from Sedgwick County. So, okay, committee, we also have quite a few written proponents. I won't read them all, but take a look at those. Lots of folks that seem to know what they're talking about, I would say. With that, we have no neutral or opponent testimony. I'll close the hearing on House Bill 2535. And I'll let you know, committee, tomorrow we have 2 bill hearings. They were informational hearings. They now have bill numbers, and that the agenda has been changed. But just for your own knowledge, one informational hearing is on House Bill 2611, and the other one is 2610. So that's what we will do tomorrow. We will also work, I think, if we have time, if it works out, 3 bills. The 2 bills that we had that had to do with CORA, that you could take your name, the legislators or the retirees, and that was 2419 and 2460. And then I also do intend to work 2536, which was the training for the guardians that, for the Alzheimer's folks. Okay, anything else for the good of the committee? Okay, with that, but committee, I will say, next week, just plan on being here. I mean, this week is not gonna be too bad. I mean, it's 5, we're gonna get out. I think tomorrow won't be too long, Wednesday won't be too long, but I think next week's gonna be pretty long, so enjoy this week a lot. So, okay, thank you all so much for your hard work. I appreciate it. We're adjourned.